3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. We're interrupting our regular schedule because as of February 19th, 2026, Prince Andrew, now Andrew Mountbatten Windsor, has been arrested by Thames Valley Police on suspicion of misconduct in public office. The charge is that while serving as Britain's trade envoy, he forwarded confidential government documents directly to Jeffrey Epstein. Today, we're connecting this arrest to what the documents already show about Andrew's relationship with Epstein. As always, every document and source we reference is available at epsteinfiles.fm. So the key documents come from the DOJ's January 30th Epstein Files release emails showing that on November 30th, 2010, Andrew forwarded official trade reports from Singapore, Hong Kong, and Vietnam directly to Epstein within minutes of receiving them from his own special advisor.
Right, and that timeline is where Thames Valley Police are focusing their investigation today. For years, the public record regarding Andrew and Epstein has been anchored in personal conduct and civil allegations. The arrest this morning at Wood Farm completely shifts the venue. We are now looking at a strict criminal framework concerning state security.
The distinction is vital for you to understand. We aren't looking at a social misstep by a royal figurehead. The documents show a government official operating in an official capacity.
Exactly. From 2001 to 2011, he held a specific taxpayer-funded role, UK Special Representative for International Trade and Investment.
And according to the Thames Valley Police statement released this morning, that role is the anchor for the misconduct charge.
It is. This was an official government appointment operating under the Department of Trade and Industry. It came with a staff, a budget, and cleared access to the internal economic intelligence of the British government.
Which brings us back to the Gmail email archive released by the House Oversight Committee, the November 30th, 2010 email chain.
The forensic evidence here is very straightforward. It's late November 2010. Andrew receives a digital briefing packet from Amit Patel,
His private secretary at the time.
right, his special advisor. And this wasn't a forwarded newsletter or a press clipping. These were internal official trade reports concerning 3 specific markets: Singapore, Hong Kong, and Vietnam.
You have to look at the economic landscape in 2010 to understand the value of those reports.
Vietnam was a surging, emerging market. It was a primary target for Western capital. Hong Kong and Singapore were the twin financial hubs of Asia.
So knowing the UK government's internal assessment of those markets,
Knowing what regulatory hurdles they were anticipating or what trade barriers they were planning to challenge, that is actionable intelligence. It is what forensic auditors call asymmetric information.
NBC News analyzed the metadata on this specific transaction. Amit Patel sends the briefing to Andrew. The timestamp shows that within minutes, Andrew forwards the entire chain to Jeffrey Epstein.
And we look at the body of that forwarded email.
Does he add context? No explanation at all.
The body of the email is completely empty. It is a blind forward.
A blind forward.
In forensic auditing, we flag blind forwards because they almost always signal a pre-existing channel of communication. You do not send dense government trade statistics to a private financier in New York without an explanation unless that financier is already expecting them.
It implies a standing order.
It suggests the relationship had evolved to a point where the flow of classified or sensitive information was routine.
And we have to factor in the recipient and the date. This is Jeffrey Epstein in November 2010.
2 years after Epstein's 2008 conviction in Florida for procuring a minor for prostitution.
He is a registered sex offender at this point.
He is. Andrew knows this.
Yeah.
The British government knows this. Yet the Gmail archive shows that the channel for high-level government intelligence from the UK's trade envoy was wide open.
This is inconsistent with the narrative Andrew maintained for years following the conviction.
It completely contradicts it. In his 2019 BBC Newsnight interview, Andrew claimed he visited Epstein in December 2010 solely to break off the relationship. He said he did it in person out of honor.
But the documents show a different reality.
You do not forward confidential Vietnam trade strategy to someone you are actively distancing yourself from. You send that to a partner. You send that to an advisor.
If the November email represents a routine flow of information, the December email is far more problematic from a legal standpoint.
CBS News flagged this second document from the Gmail archive. It occurs in December 2010. Andrew shares a file described in the subject line and the internal headers explicitly as a confidential brief.
Confidential is a specific security classification in government.
It means unauthorized disclosure would be prejudicial to the interests of the state. The subject matter of this brief was investment opportunities in southern Afghanistan, specifically Helmand Province.
We need to remind listeners what Helmand Province was in December 2010.
It was an active war zone. The U.S. and U.K. were executing a major troop surge. British forces were stationed in Helmand and taking heavy casualties.
It was the most dangerous environment the British military was operating in at the time.
So a brief on investment opportunities in Helmand is not standard corporate data. In a counterinsurgency environment, economic development is intertwined with military strategy.
Building roads or power plants in Helmand was part of the stabilization effort.
Information about where the government believed capital could be deployed revealed the military's footprint and its future intentions.
And unlike the November email, Andrew includes a specific request with the Afghanistan brief.
He does. He writes to Epstein asking for, quoting directly here, comments, views, or ideas as to whom I could also usefully show this to attract some interest.
The UK's Special Representative for International Trade is asking a convicted sex offender for advice on who should see confidential government briefs regarding an active conflict zone.
It demonstrates that Andrew was treating Epstein as a shadow advisor. He wasn't relying exclusively on the Foreign Office or the Department of Trade and Industry for strategic counsel. He outsourced it. He took a document intended for cleared government personnel and handed it to a private citizen with a criminal record and no security clearance.
Why would he do that? What utility did Epstein offer regarding Helmand Province?
Epstein marketed himself as the ultimate connector to global capital. Andrew was under mandate to show results in his envoy role. He needed to prove he could bring in investment. The documents show he turned to Epstein to locate that capital, prioritizing his operational goals over the security protocols of his own office.
This brings us to the actual charge announced today: misconduct in public office.
It is a common law offense in England and Wales. It is reserved for severe breaches of duty.
PBS News outlined the sentencing guidelines this morning.
The maximum sentence is life imprisonment. It is a criminal indictment.
What are the legal thresholds for this charge?
The Crown Prosecution Service needs to prove three elements. First, that Andrew was a public officer. The special representative appointment satisfies that. Second, that he willfully neglected his duty or misconducted himself.
And third,
that the misconduct was to such a degree that it amounted to an abuse of the public's trust.
transmitting confidential war zone briefs to an unregistered, uncleared third party
Fits the definition of an abuse of trust. It demonstrates a reckless disregard for the legal responsibilities of the office. Thames Valley Police have jurisdiction over the Windsor area where Andrew resided. They stated they opened this investigation following a thorough assessment of the documents released by the U.S. Justice Department in January 2026.
They waited for the DOJ release.
They required the forensic proof. Before the Gmail email archive release, there were unverified reports of communication. The January 30th release provided the metadata, the server logs, and the timestamps. Police operate on hard evidence.
The DOJ release provided the chain of custody.
Exactly. It moved the issue from an improper social association, which is not criminal, to the mishandling of classified government intelligence, which is.
To understand how a member of the royal family reached the point of emailing trade secrets to Jeffrey Epstein, we have to look at the forensic timeline of the relationship. It did not spontaneously begin in 2010.
The Gmail email archive maps a long-term cultivation. It starts in 1999 with Ghislaine Maxwell.
She facilitated the introduction.
The documents confirm Maxwell introduced Andrew to Epstein in 1999. The integration was remarkably fast. By 2000, there is a document referencing Epstein and Maxwell attending the Dance of the Decades party at Windsor Castle.
Hosted by Queen Elizabeth II.
That is unprecedented access for a New York financier. It shows Epstein was brought into the inner operational circle immediately, Maxwell vouched for him, and the institutional doors opened.
Maxwell's own correspondence in the DOJ release confirms her role as the conduit.
There is a draft email from Maxwell to Epstein, dated 2015. She writes, "In 2001, I was in London when Redacted met a number of friends of mine, including Prince Andrew. It is a direct admission of her role as the bridge."
But the critical operational period, the time frame relevant to the misconduct charge, is post-conviction, 2008 to 2010.
That is where the 2019 BBC Newsnight narrative completely fractures.
Andrew stated defense for staying at Epstein's New York townhouse in December 2010.
He claimed he traveled there to end the friendship in person.
The emails show active collaboration during that exact window.
Days before that New York trip, He is sending the Afghanistan brief. He is forwarding the Vietnam trade data blind. The correspondence is functional and cooperative. That doesn't add up with a planned severance of ties.
The visual evidence from that trip aligns with the emails.
The J-Mail archive references the photographs of Prince Andrew leaving Epstein's New York townhouse in December 2010. The emails provide the operational context for why he was there. It was a business continuation.
CBS News reported on a separate email that adds another layer to the power dynamic, the Mandelson connection.
Peter Mandelson was the former British business secretary and EU trade commissioner. In 2016, he sent an email directly to Epstein.
What did he say?
He wrote, "In hindsight, you were right about staying away from Andrew."
You were right about staying away from Andrew.
It completely inverts the narrative Andrew presented to the public.
Mm-hmm.
Andrew claimed he ended the association. Mandelson's email to Epstein indicates that Epstein was the one who initiated the distance.
Epstein pulled back.
It suggests Andrew had become a liability to Epstein, or perhaps his utility had simply expired.
Andrew stepped down from his trade envoy role in 2011.
Which meant he no longer had access to the briefing packets. Epstein collected individuals for their specific utility. Once Andrew lost the office, the intelligence flow stopped, and the relationship cooled.
We cannot audit these files without addressing the primary victims of this network. The institutional pursuit of the trade documents today is directly linked to the civil cases.
Al Jazeera and NBC News have extensively documented the allegations of Virginia Roberts Giuffre. She alleged she was trafficked by Epstein and Maxwell to Andrew.
She was 17 years old at the time of the alleged offenses.
She alleged a sexual assault occurred on 3 separate occasions, in London at Maxwell's home, in New York, and at Little St. James in the U.S. Virgin Islands.
Andrew repeatedly denied the allegations and questioned the authenticity of the 2001 photographs showing him with Giuffre and Maxwell.
He suggested the image might have been doctored, but the J-Mail archive contains a significant piece of evidence regarding that photograph.
The 2015 draft email from Maxwell.
In that same draft, Maxwell writes about the event in London. She confirms that a photograph was taken because Giuffre wanted to show it to friends and family. In private correspondence, Maxwell authenticated the event that Andrew denied in public.
The legal resolution to the sexual assault allegations was a civil settlement.
In 2022, Andrew settled the lawsuit brought by Giuffre in the U.S. British media reported the settlement was for approximately $16 million.
He made no admission of guilt.
No admission of liability. But the settlement closed the civil avenue. It prevented a trial where he would have been deposed under oath and subjected to cross-examination.
And we must state the fact clearly regarding Virginia Giuffre.
She died by suicide in 2025 at the age of 41.
Her family released a statement today, February 19, 2026, directly addressing the Thames Valley police arrest.
The statement reads, "At last, today, our broken hearts have been lifted at the news that no one is above the law. He was never a prince. For survivors everywhere, Virginia did this for you."
The timeline of the civil case and Giuffre's death explains the specific legal strategy unfolding today.
It is a pivot. With Giuffre's death, the potential for a criminal prosecution regarding the sexual assault allegations effectively disappeared. The primary witness is gone, and the jurisdictional hurdles between the U.S. and the U.K. were already immense.
So law enforcement focused on the administrative paper trail.
It is a standard forensic auditing strategy when pursuing high-profile targets. You prosecute the documented administrative crimes when the primary offenses cannot be tried. The misconduct in public office charge relies entirely on emails, metadata, and server logs. It does not require victim testimony. It is the only viable mechanism left for criminal accountability.
Let's review the logistics of the arrest itself.
NPR and PBS News confirmed the operational details. At 8:00 a.m. this morning, February 19, 2026.
Which is Andrew's 66th birthday.
Unmarked police vehicles arrived at Wood Farm on the Sandringham estate in Norfolk.
Wood Farm is a significant location change for him.
It is a farmhouse on the edge of the estate. He was evicted from the Royal Lodge in Windsor earlier this month. The physical relocation to Norfolk represents a total institutional demotion.
How was the arrest processed?
He was transported to Elsham Police Station and held in custody for 11 hours.
Were there any special accommodations made?
No. According to the police logs reviewed by journalists today, he was placed in a standard custody suite, a cell with a bed and a toilet. He was processed identically to any other suspect, fingerprinted, DNA swabbed, and interviewed under caution.
He has since been released.
Released under investigation. He has not been formally charged by the Crown Prosecution Service, but the criminal inquiry is active and ongoing.
The reaction from the British state institutions has been swift and unified.
NBC News published the statement from King Charles III. It was signed Charles R. It stated, "I have learned with the deepest concern. The law must take its course."
The law must take its course.
It is a deliberate constitutional phrase. It signals absolute non-interference. The monarchy is formally separating itself from the individual. Buckingham Palace also issued a brief statement confirming they are ready to fully cooperate with the police investigation.
And the government response.
CBS News reported the statement from Prime Minister Keir Starmer. He said simply, "Nobody is above the law."
The executive branch and the head of state are presenting a unified front.
They're cutting him loose. He is facing the justice system entirely isolated from the protections of the state.
This institutional isolation has been a sequential process over several years.
Charles stripped Andrew of the HRH title in January 2022, following the civil lawsuit developments. The eviction from the Royal Lodge in February 2026 severed his remaining physical ties to the center of royal power. The arrest today is the culmination of that systematic exile.
When we synthesize the document releases with today's law enforcement action, a very clear trajectory emerges.
You track his status over 2 decades. He transitions from a trade envoy with highest-level security clearances to an Epstein associate, then to a civil defendant who settles for $16 million, then stripped of his titles. And today, a criminal suspect held in a standard police cell.
The documents answer the core question of why a British royal was sharing confidential intelligence with a convicted offender.
He viewed Epstein as a peer in global finance and a necessary advisor for his own career objectives. The documents show he valued Epstein's network more than the legal obligations of his public office. He bypassed the conviction because the transactional relationship was too critical to his operations. He used state secrets as currency.
And the misconduct in public office charge is the legal system's mechanism to address that specific transaction.
They're using the rigidity of common law to address a relationship that evaded criminal scrutiny for decades. The emails are indisputable.
What remains unknown at this hour?
We know the trade reports were transmitted. We know the arrest was executed. What we do not know is whether the Crown Prosecution Service will officially authorize charges.
The CPS authorization requires meeting specific legal thresholds.
They must determine if there is a realistic prospect of conviction based on the evidence and whether a prosecution is in the public interest. Given the Prime Minister's public statement today, the public interest test is clearly met. The evidentiary test will rely heavily on the exact contents of that confidential Afghanistan brief.
And we have to consider what other documents might be in the unreleased files.
The January 30th DOJ release is just a fraction of the Gmail archive. If Thames Valley Police uncover a 10-year pattern of unauthorized intelligence sharing matching his entire tenure as trade envoy, the scope of this criminal inquiry will expand exponentially.
We'll be watching this closely. If more documents surface or charges are filed, we'll be back with an update.
You have just heard an analysis of the official record. Every claim, name and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.